for us today. Also in the room is Tom Liddy, Jack O'Connor, Karen Hartman-Tellez, and Rosa Aguilar.
All right, and just for the record, Ms. Krager, your name is Craiger?
That's correct, Your Honor.
I just want to make sure that we have that down right when we call on you. And we're here today to argue a couple of motions to dismiss filed by both the Hobbs parties and the Mays parties. And we also have the motion to inspect ballots that was filed by the plaintiff and expedite discovery filed by the plaintiff, and Maricopa County was going to respond to those. I have in the courtroom today, and I want to make sure I have her name spelled correctly. Is it Morgan?
Morgan, Your Honor.
Morgan. I have Miss Morgan here in the courtroom. She filed a notice to intervene last week, or a motion to intervene, which I denied last week in writing. She is back again today. She's filed a kind of an amended, she called it a revised motion to amend, and at least in this particular motion, I don't even know if any of you have even seen it. I don't believe oral argument is necessary on this, and I'm not inclined to spend much time on it. But Miss Morgan, the way the court reads your motion is you're basically arguing for the integrity of the plaintiffs that you believe they shouldn't be plaintiffs. Specifically, Ms. Kinch, her motives, and Ted Boyd may not have his name as Ted in the voter rolls. I don't believe that's the law or fact that is what I talked about when I said that there should be a common law or fact at issue in this case. The issue of whether or not Ms. Kinch, why she's doing this and whether it affects the integrity of Mohave County or other things is not an issue that I should be, from the court's perspective, considering in this. She has filed it. She has the right to file it. And those are just issues that I cannot address. So I'm going to deny, again, your motion to intervene in this case. I do appreciate you explaining in more detail why you filed the motion to intervene in the second. At least I know now that it isn't a legal issue related that I have to worry about. This is more of a whether or not they should have done this, whether Mr. Boyd or Ms. Kent should have done this. But I don't believe that's enough to allow you to be an intervening party in this case, and I'm making that ruling based on the rules. So we'll move forward from that. Having made that ruling, I guess I would like to get started. Mr. Barr or Mr. Gayona, either one of you decided who's going to go first. We have these two motions to dismiss. What I would like to do, and Mr. Lasoda, you can stop me if you don't like this, is I'd like for both of them to argue, and then you respond, and then they get to go again. Do you have an objection to that?
No, Your Honor.
All right. Mr. Barr, you have your mute lifted. I'm assuming you want to go first?
Yes, Your Honor.
All right. So Mr. Barr represents Ms. Mays, but both of them have filed motions to dismiss today, and both of them have the right to argue that, and then the plaintiff gets a right to respond. I would open the door to any other county member that have joined in these motions if they want to add anything, please let us know. Maybe you can do that through the chat line or something. Let us know if you want to speak. With this many people online, I don't want to call everybody in order as I often would do if I had 3 or 4 attorneys. But if people want to speak on these particular issues and they're representing one of the counties that's a nominal party in this, I certainly respect the right that you have at least to add something. But the ones of you who have joined. It's in the file. And we all know that you've joined in these particular motions. And if you have additional things to say, let me know and I'll give you a chance. But if not, I'm just going to go with what I've mapped out so far. So, Mr. Barr, you're going to go first. Go ahead.
Thank you, Your Honor. Dan Barr here for Attorney General-elect Chris Mays. Your Honor, to start off, there's no special action relief available in an election contest. Judge Randall Warner ruled 3 weeks ago in Mr. Hamadeh's first election contest lawsuit that mandamus relief is available only where there is no adequate remedy. There is an adequate remedy here, Your Honor, which is the election contest statute. That means that the Republican National Committee cannot be a party in this case. because only electors of this state may be parties in election contest state action. It's not an issue of standing as set out by the plaintiffs in their response, but one of statutory authority to bring an action. And since the Republican National Committee is not an elector of the state, they can't bring an action. The response spends a few paragraphs saying, well, maybe they could have associational standing because they have members that are electors of Arizona. Well, I guess if that were the law, then, the Elks Club could be an elector, or a private hospital, a private employer could be an elector, any sort of association of people could be. And so that's clearly not the law. Having no special action relief also means that the plaintiffs cannot seek some of the relief they are seeking in this case. The court has no statutory authority to order Maricopa County to allow people to vote who, for whatever reason, decided not to vote during the 26 days that they had to vote for the November election. The relief, Your Honor, is limited solely to that which is set out in ARS 16-676. So the special action relief that the plaintiffs seek here is simply not available because special action relief isn't available. Now let me talk about the insufficiency of the pleaded election contest complaint. Simply, Your Honor, the overview is there's no there there. It is a lawsuit in search of facts. They have had 5 weeks to produce any facts on which to plead for relief, and they haven't done so. Despite the fact that they have named 15 counties as defendants in this case, 5 weeks after the election, I very much doubt that the plaintiffs today could name one person from each county who actually was prohibited from voting in any way and unable to exercise their right to vote. And by identify, I mean provide a person with a first and last name who was unable to vote for any reason. The fact that they can't do that speaks volumes to the weakness of their complaint. Indeed, as we set out in our reply, every voter in Maricopa County can check online to see whether their vote was counted. There's nothing to prevent plaintiffs from looking to see if there are actual people with first and last names who fulfill any of the claims in their complaint. But they haven't done so. And the fact that they haven't done so speaks volumes about the weakness of their complaint. Looking at their complaint, Your Honor, plaintiffs do not allege fraud. Instead, they allege, one, misconduct by elections officials, but they never say what that misconduct was or who those officials were or where the misconduct took place. They allege ballot duplication. They allege electronic adjudication errors and unlawful counting of ballots. Plaintiffs have pleaded no facts to support any of these claims. Instead, they plead them on what information and belief. But, Your Honor, the complaint has shown they have no relevant information to base any claims on, and whatever beliefs they have are totally unsupported by facts. And we'll just, Your Honor, take a look at each count of the complaint. Count 1 regards alleged misconduct and erroneous counts of votes concerning provisional and early ballots that they claim were not counted. Now, as Your Honor knows, as a matter of law, as stated in the briefs, honest mistakes and mere omissions cannot constitute misconduct as a matter of law. Plaintiffs cite no facts in their complaint that could support that any election official anywhere in the state of Arizona engaged in misconduct. Instead, and they state this at page 18 of their response, instead they argue that the, quote, accumulation of even innocent mistakes begat substantial questions concerning the accuracy of the final count. Your Honor, but, you know, innocent mistakes, no matter how many of them, do not constitute misconduct. I mean, their complaint is literally 0 plus 0 plus 0 plus 0 equals something more than 0. And that simply isn't so. The alleged accumulation of innocent mistakes are still innocent mistakes, and these are alleged innocent mistakes, by the way, and cannot constitute misconduct as a matter of law. In addition to pleading no facts regarding misconduct, plaintiffs plead no facts that if the misconduct occurred, it may have affected the election in any way. There are no facts that anyone counted any votes erroneously, and certainly no facts to the extent that and if there was a, quote, accurate count, that would have resulted in somebody else winning the Attorney General's race. Now let me get to count 2 of the complaint, which alleges that Maricopa County poll workers denied provisional ballots to unspecified number of people. The complaint does not identify even one voter who was denied a provisional ballot or any facts on where or when this supposedly happened. There are no facts whatsoever regarding alleged misconduct. Count 3 of the complaint concerns alleged duplication errors. In this portion of the complaint, Your Honor, the only facts that plaintiffs have is stating that 2 years ago, during the 2020 presidential election, Maricopa County Ballot Duplication Board erroneously transposed 0.37% of the sample ballots designated for duplication. To which anybody would say, so what? I mean, this happened 2 years ago. It in no way reflects on anything that happened today. It certainly in no way proves anything or is a sign of anything regarding the 2022 Attorney General race. Then next, Your Honor, we get to count 4 of the complaint, which is alleged electronic adjudication errors. Plaintiffs say that a hand audit of the governor's race revealed only a single instance where a vote for one candidate for governor was tabulated for another candidate. There are no facts regarding the Attorney General's race. To say that, this allegation regarding one vote in the governor's race somehow states a claim for an election contest in the Attorney General's race is frankly absurd. They then go on to talk about undervotes. And as we all know, undervotes are perfectly normal fact of life in election. They don't mean anything. The further one gets down the ballot, the more undervotes there are because a lot of voters don't know who people are. And as probably the court is well aware, when you get down to voting for judges, there are a lot of undervotes. And it doesn't mean that any misconduct has taken place. Certainly doesn't mean that any fraud or untoward things have taken place. Finally, Your Honor, we get to count 5, which the alleged signature verification errors. As a substantive matter, plaintiffs do not allege that a single ballot was illegally counted on this basis. But as a matter of law, Your Honor, this claim is barred by laches because it is dependent upon arguing that there is some flaw in the elections procedural manual that was written in 2019. And so plaintiffs have now sat on their hands for 3 years and waited until after the election. And that is clearly barred by laches. And also as a matter of law, Your Honor, a procedural challenge to the elections procedural manual as a matter of law must be challenged before the election is held. and that the Arizona Supreme Court held that 35 years ago in the Tilson versus Mofford case. So as a procedural challenge, count 5 must be dismissed. And frankly, Your Honor, the first go-around of this very same lawsuit that was filed 3 weeks ago in Maricopa County Superior Court, the previous lawyer did voluntarily dismiss count 5 because he acknowledged that it was a procedural challenge. So for the reasons I've discussed above, Your Honor, this complaint must be dismissed for failure to state a claim. I'll talk about 2 other things, Your Honor, that getting back to the relief that they're requesting. And I said, as a matter of law, they can't seek mandamus relief. But, you know, if you look at their response, it really sort of gives away why they can't get any relief, because they cite these things about relief that they're seeking with absolutely no authority supporting it. At page 8, they state, the court is empowered by statute to furnish any and all remedies requested by the statement of election contest, period. Citation to nothing. And that shouldn't be a surprise because they're not entitled to that relief. On page 8 and 9, they state, quote, the power to affirm or annul the outcome of an election necessarily and intrinsically presupposes a subsidiary authority to make orders regarding disposition of particular ballots. Your Honor, I will admit I have no idea what that statement means, but there's no citation to that either. And so I think the fact that there's no law supporting these, frankly, wild statements of law is further indication why they're not entitled to relief. They're entitled only to the relief prescribed by the election contest statute. And with that, Your Honor, I'll turn it over to Mr. Gaona, unless Your Honor has any questions.
Thank you, Mr. Barr. I don't at this time. Mr. Gaona, your turn.
Thank you, Your Honor. And I will try my best to not be repetitive of anything Mr. Barr said, and I will also try to be very brief here. Your Honor, whatever plaintiff says in a case such as this where the plaintiff doesn't allege fraud and in fact expressly disclaims a fraud theory, the plaintiff bears the heavy burden of establishing that the result of the election would have been different, assuming that there was misconduct. That doesn't just matter for this case, Your Honor. As I explained just a few hours ago to Judge Thompson in another election contest, it's about the very stability of our election system and the strong public policy that you see in the case law dating back years and decades that favors the finality of election results. To allow, as plaintiffs urge here, an election contestant to declare on mere information and belief, no less, that an election result is uncertain, and then allow them to pour over voted ballots and proceed to trial would open the proverbial litigation floodgates. Every election could be contested and proceed to trial. That cannot and should not be the rule, and this court shouldn't be the one to set that dangerous precedent. Now, plaintiffs in their response accuse those on this side of the V who filed motions to dismiss of attempting to apply the wrong standard in evaluating the motions to dismiss their election contest. And that's just plain wrong. No one disputes that a motion to dismiss an election contest is evaluated under Rule 12b-6 and Rule 8a. But like any other claim, the court must also consider the underlying substantive law. If you put those together here, Your Honor, what that means is that the court cannot make unreasonable inferences. That's the Jett case, J-E-T-T we've cited. An election contest cannot rely on mere conjecture or public rumor. That's the Hunt decision from 1917. This court must apply all reasonable presumptions in favor of upholding the election. That's the Moore decision from the Court of Appeals. And it must also presume that election officials acted at all times in good faith. That's Hunt again. When you take those standards and apply them to the entirely speculative allegations that Mr. Barr just went through as to each count in this complaint fails to state a claim and should be dismissed. I do want to stress, I'm not going to repeat anything Mr. Barr said, Your Honor, but I do want to stress one more issue that relates to count 5. Count 5 is about the alleged invalidity of an elections procedures manual provision that relates to what is or is not a voter's registration record. The Secretary agrees that that claim is barred by latches and also agrees that it's just wrong as a matter of law. The legislature changed this statute just a few years ago to expand it to refer to a registration record. And what the plaintiffs are urging you to do here is to say that the legislature, in enacting that change to law, actually meant nothing. And as a corollary, they're also urging you to disenfranchise some unknown number of voters in Arizona and throughout Arizona of all political parties and political persuasions to disenfranchise their votes after the fact based on a claim that if it had any merit, which it does not, should have been brought years ago. Your Honor, the Secretary has served as Arizona's Chief Elections Officer for 4 years. She believes that every legally cast ballot should be counted. Those ballots have now been counted. And she strongly urges this court to reject plaintiffs' request to disenfranchise untold number of Arizonans and overturn the result of this election, and thus urges the prompt dismissal of this action. Unless Your Honor has any questions, that's all I have for now.
Thank you, Mr. Gaona. Mr. Lasota, your turn.
Thank you, Your Honor. So I'd like to start by just going through, we just heard about, well, you know what, if you let this proceed, every single person who ever loses an election is going to file an election contest. So I think we need to look at, first of all, what we're talking about in terms of how close this election was. The contestee, Ms. Mays, filed a supplemental authority on a case that was dismissed. Well, the vote difference there was 120,000 votes. So the vote difference here is 511. That's 0.02. We think by percentage, that is the closest statewide candidate race in state history. So we're not talking about, some kind of outlandish theory on trying to overcome a huge number of votes. So to put that in perspective, in terms of the mandatory recount that the legislature mandated, that's 0.5%. So for this race, that's 12,500 votes. So we have a vote difference in this case, 511 votes. That's essentially 0.04%, 0.04 of what the legislature says is recount territory. So I think that this notion that finality is important in elections, that's clearly the case. I would never dispute that. But I think that in terms of not just finality, but making sure we have an accurate vote count, I think that's important too. And that's why we've brought this case. And I'm going to go through our allegations. It is not true to say that it's just pure speculation. That's just totally inaccurate. So the other reason it's important is, sometimes it takes a lot of votes that weren't counted properly to overcome a certain margin. In this case, we have a wide disparity between how election day voting went in terms of how those people voted. They tended to vote for Republicans, and how early ballots went. Those people tended to vote for Democrats. So, we're probably talking about a situation where if votes have not been counted, it would significantly favor one side or the other, as opposed to following the overall margin of 0.02%. So, there's a lot of critiques about what's been alleged, but with over 2.5 million votes cast, we have to remember that even very small mistakes can make the difference in a case such as this. So, in terms of the defendants continually misstate the standard. So I'm going to quote it one more time. And we have not alleged fraud. That is not part of our case. That is accurate. So, but I'm just going to quote this. Mistakes or mere omissions on the part of elections officials even though gross, if not fraudulent, will not void an election unless they affect the result or at least render it uncertain. You know, this business from Mr. Gaona that, oh, well, you have to show you would have won, not true. So, and I know he said, well, you know, Moore v. City of Page interpreted Finley v. Sorensen. Well, guess what? Moore v. City of Page is a Court of Appeals decision. So Finley v. Sorensen is a Supreme Court decision that does lay out the standard, not this business about you have to show you absolutely unequivocally would have won. The other thing that I think is interesting is we have a ballot inspection statute. We've obviously talked about that, but if the defendants were correct that basically you have to put every single detail forward, then why in the world would the legislature make provision for inspection of ballots? It doesn't make any sense. The legislature obviously thought that might be important in an election contest, and obviously if you had to know that ahead of time, it would be a chicken and the egg situation. So they made that provision, and I think that's meaningful. The other thing about it is the defendants seem to argue on the one hand that, well, you know what, we're the ones who are standing up that you know, for the voters. I think the reality is what they're claiming is that if a vote isn't counted at all, then that can never go into the actual prong in the statement of contest of an erroneous vote count. And I think that's simply not true. I think that statute clearly means, look, if a vote wasn't counted at all and should have been counted, that is an erroneous vote count. It doesn't just apply to votes that the elections officials decided to count or that the machine said to count. So in terms of the actual claims and the parties, I don't know why Mr. Barr keeps spending time on the RNC. Everybody else has standing. That's just a complete sort of red herring, nothing that the court needs to spend any time on it. But we basically have a variety of different buckets, if you will, and they're all important. The undervote issue, and we've talked about what we need for that. You know, we've got our expert essentially saying, look, the machines are not set for to pick up enough of the part that's filled in. We now have reports back on this, and we do think that this is affected by the type of pen, the color pen that somebody uses. I don't know why people don't just use the black pen. I mean, you know, I wish they would. Some people, for whatever reason, think they have to use a different color pen, and I know this has been talked about before, but it's in a different context that these these electronic adjudications simply are not good enough to pick up a lighter colored ink. So you have undervotes you have votes for candidates that are being wrongfully counted or not counted, you might say, as undervotes. So I think that's an important one, that an examination of the actual ballots. And we're not talking about, we're not talking about all the ballots. We're basically, so that's Maricopa County. Those are the undervotes. Pima County, we have essentially, we have a huge number of duplications. The hand count seems to reveal that overvotes are votes for Mr. Hamadeh are being counted as overvotes for some reason. So, I think the bottom line is, with an election this close, we need to get to the bottom of the claims that we've made, and to do that, we need access to the ballots. I know that kind of goes into the next motions that we'll be arguing. So we also have the provisional ballots that we've argued. People that we think mysteriously, we have declarations on these also, mysteriously are not able to vote on election day. We can't figure out why. One of the things, and you heard Mr. Barr say, well, these guys have had all this time, and why can't they act? Well, we're not going to go to every single voter and say, hey, you know what? Can you enter your information on the into the system? And we'll go through all 1.5 million or whatever it is in Maricopa County. No, what we've asked for specifically is, because we have these provisional ballots, and I asked the county, Maricopa County, for this list. It's not been produced, but we simply need a list of these provisional ballots that were not counted, and specifically the ones that, not the ones that weren't counted because the person, well, because, essentially the ones that weren't counted because the person, quote, wasn't registered or was only registered federal only. We obviously have voter data at our that's accessible to us that we can, that's just something we need. We do have a number of reports of that happening. And I will also note that in terms of the fallibility of elections officials, there was an instance, I think, where 6,000 federal only ballots were sent to people these are early mail-in ballots when those people should have received mail-in ballots. They should have received state, they should have been able to vote in the state election. So, and that error was corrected, but this notion that these kind of mistakes aren't made it's not accurate. So we have that. We have the check-in, check-out procedures. And on this one, I would like to note that Ms. Krager provided some useful information. We have, in terms of that the county did in fact count those, the people that were entitled to vote, but sort of would have been disenfranchised because they checked in somewhere and didn't check out. That was actually useful information. We have gone through that, and our data is, we're not done yet, but at least what we've been able to go through, we haven't found anything that contradicts that as of yet. So that would be an example where, okay, we're able to actually find this out, and we would not pursue that particular bucket of votes. So that essentially, we also have I think I've talked about adjudications and duplications in both Pima and Maricopa County. We have the signature mismatch issue, and here's the thing on that one. It's not true that someone would pick out a voter and say that your vote doesn't count. So that's not true. What the court said in grounds was, well, if you've got illegal votes, then you basically just, you don't go voter by voter, you go by percentages. The only other thing I'd say about that is that count has been also misstated by the other side. It's not an issue of, look, the elections that we're saying the elections procedures manual happens to be wrong on that. What we said is our complaint, to the extent the elections procedures manual says otherwise, that doesn't count for anything. Because this is simply an illegal process. Mr. Gaona did say that the legislature changed that statute. That's correct. But I don't think anybody would get like a request to be on the permanent early voting list. I don't think anyone would mistake that for a, quote, registration record. I think that's why we have courts. I think the court needs to say exactly what the legislature intended with that statutory change. It's not as broad as what Mr. Gaona claims and the other defendants claim, but I would concede that is something that they did make the change, and so courts have to say, well, why did they make that change? I mean, they could say any signature on file, and then maybe Mr. Gaona and the other defendants would be correct. So, in terms of the, I'll just talk briefly about latches. I think it's a classic heads I win, tails you lose argument. I mean, the other side demanded that this case be dismissed, despite the fact that even if it was not ripe, it would have been ripe within days. So, and this notion that it's exactly the same complaint, not true to begin with, but the bottom line is, even if it were true, it's still the product of information that we're gathering all the time. It's often incomplete. It's often hard to interpret. I'm not blaming anyone for that, but this is the nature of an election contest. It's just something that is done very much on the fly. So in terms of what else I'd like to say, so the other thing about the undervotes, this is something I meant to mention, is I think we have more undervotes than one would expect by a significant margin. We've got over 50,000 undervotes in Maricopa County. Now, Mr. Barr mentioned that, as you go down the ballot, you tend to have fewer undervotes, but this is a disproportionately high amount by about 12,000 in our minds. So I know that's a statistical aberration, but in conjunction with what our expert is telling us and the feedback we're getting on the ground, I mean, we didn't just make these things up. I mean, these are things that are there, and we think that we have the right to essentially file this election contest. And the other thing is that, if we don't have a remedy via election contest, then we do have a remedy via mandamus. So the other side can't have its cake and eat it too on that, oh, well, you don't get mandamus because you've got this great, wonderful, speedy remedy by way of an election contest. Well, that's what I think what Judge Warner said was, yeah, you can maintain your election contest, so you can't maintain mandamus at the same time. But they're trying to say, no election contest, and because in a more perfect world for you, you could have maintained your election contest, no mandamus relief also. That doesn't make any sense. In terms of the, so I mean, I think the bottom line is we have a very historically close election. I think this parade of horribles about, well, if you allow this and allow, every single person who challenges is going to challenge, I think doesn't really add up. I think that, we had, I know that in terms of, the elections officials, so just overall, if you look at the other side keeps talking about finality and that has to take precedence over everything. I mean, the bottom line here is particularly, and this is just a general observation. This is not so much, other than the check-in, check-out procedures and potentially provisionals, not part of our complaint. But, Maricopa County admitted that 31% of their vote centers were not functioning properly on election day, and it was because their printers weren't working. Well, I mean, that's a pretty fundamental thing. And they basically, keep saying, look, nothing to see here, move along, trust us. And, it's not a bad thing that in a race this close, that there's actually an election contest where that there's an ability to check the ballots to see if they're correct and to essentially have each side get the ability to make their case. So I think, Your Honor, we would urge that the motions to dismiss all be denied. Thank you.
Thank you, Mr. Lasota. I had missed earlier on the chat room what I had suggested they do. Somebody had wanted to talk, and that was Maricopa County. What I'm going to allow them to do is talk about this issue on the motion to dismiss, and then I'll let Mr. Lasota have a response to that before I go back to Barr and Gaona. So, Ms. Kreger, did you want to address the motion to dismiss as well?
Thank you, Your Honor. We joined the Secretary of State's motion, and I, don't want to belabor legal issues and points that have already been made. However, I do want to reiterate that plaintiffs have failed to meet their burden. The entire contest is based on pure speculation and hypotheticals. In fact, the claims are based almost entirely upon information and belief. What plaintiffs have done is taken publicly available numbers related to the election and provided theories about the basis for those numbers. But these are purely hypotheticals and in most cases are entirely wrong. And this is clear based on publicly available information for which this court can take judicial notice pursuant to Coleman v. City of Mesa, 230 Arizona 352. For instance, plaintiffs talk about people who checked in on election day and then did not check out and cast a provisional ballot at a second vote center. I believe this is the issue that Mr. Lasota was referring to that I provided information about. That's correct, I did. The county has identified 146 voters where this happened, but 109 of those ballots were tabulated. That occurred because the county reviewed the number of ballots cast at the first vote center versus the number of check-ins and determined that there was a variance. So it could reasonably determine that the person had not cast a ballot at the first vote center. So those ballots were counted. The remaining ballots were not tabulated because 20 were federal-only voters who voted a full ballot, so that could not be counted by law. 2 people declined to place their ballot in a provisional envelope, so those ballots also could not be counted. That leaves just 15 of those voted ballots that are in question. This is not a significant number and not significant to move the needle in this case. I also want to point out that Mr. Lasota has made a comment about a percentage of vote centers with printers that weren't functioning properly. The reality is that the printers printed 100% of ballots that were readable by the human eye, and 100% of those ballots that were put into door 3 were counted at central count tabulation. So that issue has been discussed and resolved, and it actually was litigated on election day, and the court determined that there was no basis to keep the polls open. Plaintiffs also allege upon information and belief that there were duplication errors, but they allege no facts at all based on the 2022 election to support that claim. Instead, they rely on an error rate that was determined in a case during the 2020 election cycle. This rate is not applicable, but even if it was, this 0.37% error rate alleged by plaintiffs would result in a finding that just 44 ballots were duplicated incorrectly. 11,918 ballots were duplicated in the 2022 election. 0.37% of that number is 44. And there is no basis to assume that these would all be errors in favor of the plaintiff Hamadeh. Plaintiff also talks about 1,942 provisional ballots cast and speculates upon information and belief that these are people who voted in previous elections and nothing had changed. This hypothetical is again incorrect.
Craig, before you go on, I guess I'm confused about your numbers there. The 11,000 was the number used to come up with the 0.04 from the number of votes in that previous election, right?
No, so 11,918 are the number of ballots that were duplicated in total in Maricopa County in the 2022 election.
Out of 2.5 million or whatever.
1.5 million in Maricopa County, approximately.
So that's where the 0.04% came.
The 0.37% came from the Ward v. Jackson case that was litigated in the 2020 election cycle. And the plaintiffs have taken that number with no basis and tried to apply it here in the 2022 election cycle. And, as a matter of law, that's improper. It's not applicable. But even if it were, if we applied that 0.37% to the total number of duplicated ballots in 2022, the error would only be there would only be an error in a total of 44 ballots.
I guess that's where I was getting confused. So it's not, I thought that number you would multiply by however many votes there were this year to get, if you were using that number.
No, the number of ballots that were used in the review in the Ward v. Jackson, they reviewed 1,629 ballots. And that's where they determined the 0.37% error rate, and then they extrapolated from that. And also of note, Your Honor, is that some of those errors favored Biden and some of those errors favored Trump. There's no basis to believe that any error goes, in one candidate or the other candidate's favor.
All right, thank you. Anything else?
Yes, Your Honor, just a few more points. Plaintiffs talk about the 1,942 provisional ballots cast and speculate upon information and belief that these are voters who had voted in previous elections and nothing had changed. This hypothetical is incorrect, as I said. These voters are coded as B12, which indicates that they were ineligible to vote in this election. The reason they were ineligible to vote for all but 7 of these voters is because they registered after the October 11th registration deadline. So if you were to query those voters today, it would show them as eligible to vote in the next election cycle because they have met the deadline. But for the 2022 general election, they were not eligible to vote. The remaining 7 were not eligible because they had registered from a commercial address. Finally, in the most far-reaching example of pure speculation is plaintiff's assertion that 50,246 undervotes in the Attorney General's race were, upon information and belief, caused by people who chose not to use the writing implement recommended by the election department. There is absolutely no basis in fact for this assumption, and it is, again, wrong. First, this 50,246 out of the more than 1.5 million ballots cast in Maricopa County is entirely within the normal range of individuals choosing not to vote in a particular race. This happens in every election. In fact, in the August Republican primary for Attorney General, more than double the percentage of voters undervoted that race. 33,132 voters out of 504,972 left that race blank. And notably, plaintiff Hamadeh brought no claim of an erroneous vote count in that election. Moreover, under the plaintiff's theory of incorrect writing implements, the entire ballot would be blank and unreadable, not just the Attorney General's race. But Maricopa County had a total of 282 blank ballots. 276 were early ballots, and only 6 were Election Day ballots. An election contest must be based on facts and not speculation and conjecture. The county has provided a massive amount of information and public records requests to the plaintiff's attorneys. They had this information in advance of this. And for these reasons, because they have not met their burden, the county asks that this case be dismissed.
All right, thank you, Ms. Krager. Mr. Lasota, you get to respond to that before I go back.
Thank you, Your Honor. So the first order of business, I think, is the 1,942 provisional ballots. I mean, we understand that if someone's not registered 29 days before the election, they're not eligible to vote in this election. I'm not talking about those people. Those are people that were properly given a provisional ballot that should not and did not count. What I'm talking about, and there always are some of those people, what I'm talking about are people that were given a provisional ballot and somehow weren't found on the rolls, even though they are a properly registered voter. Those votes should count. I think everybody in this room would agree on that. So, you know, Ms. Krager talked about how she's provided the other information with regard, and this is the other bucket, the check-ins, check-outs. That's true. I guess I don't know why she can't provide the information on the provisional ballots. Because they've obviously gone through that information and come to the conclusion they've come to. We'd like to go through it and we want to reconcile it with the people who have told us, look, you know, I don't know why I wasn't allowed to vote, and that we have in our data as being actually that they were eligible. So the undervote issue is, I think that what the county said is not at all what we're claiming on that. There are tens of thousands of legitimate undervotes in this race. There's no question about that. You know, some people just are not going to choose a candidate. Ms. Krager's primary election example is not a very good one, because whereas in a primary, a Republican voter may not have a candidate they actually like more than the other candidates. A lot of times in a general election, people, even if they couldn't pick a candidate out of a lineup, is going to vote their partisan affiliation. So, I mean, it's not really useful to extrapolate much from a primary election. The other thing is look, we're not talking 50,000 undervotes. What we're talking about are undervotes that were not undervotes. They were votes that were cast for one of the candidates, and because the machines just were not set at the right setting, that they were unable to be picked up by the actual by the machines. And I know it may sound a little bit like splitting hairs to talk about a lighter colored ink, but in an election this close, that may make the difference, is that you've got a lot of generally Republican voters who I don't claim to know why, or that this is particularly that I would advise it, but you know, just because somebody decides they need to vote with a certain ink color, even if that's erroneous, that should not affect their vote. And that is the information we are seeking from this court. And so we're not talking every undervote. We're not saying there were 50,000 undervotes and every single one of those people voted for Ms. Mays or Mr. Hamadeh. A lot of those people didn't vote for either one of them. But at the same time, we think a number of those people did vote and they favored Mr. Hamadeh, and that has been improperly counted as an undervote. So thank you, Your Honor.
All right, thank you. Mr. Barr, the response?
Thank you, Your Honor. I'll be brief. Just a few quick points. I was sort of amazed to hear someone who has filed a verified complaint in court to say, actually, we're still trying to find things out. Okay? I mean, the point you're trying to find things out is before you file a complaint, certainly before you file a verified complaint where someone is attesting under oath that they believe the facts to be true, and to be stating 5 weeks after an election or 2 weeks after you filed a complaint that you're actually still trying to find things out is just amazing. Okay. And certainly when we get to a talk of sanctions later, that will bring it up. Yes.
Limitations on what they can look at. I mean, that's this whole inspection of ballots thing. Isn't there some limitations that they cannot do certain things before they get authority from the court?
Your Honor, they can, under the statute, they can ask for a 3-person committee to examine the ballots. That's certainly true. But when we hear that we're now finding out that they find out that one of their claims isn't factually supported, is really quite something. Then we have the statement that this really isn't such a bad thing in a race this close, that there's an election challenge to make sure that the count is correct. Well, there's something that's statutorily provided, Your Honor. It's called the recount. And that's happening right now. And that happens in races that are close. It doesn't mean that in close races that you can file election challenges that fail to allege any facts that would constitute misconduct or anything else that would qualify for relief under an election contest. Having a close race doesn't mean that you get a free pass on asserting facts to constitute misconduct or to constitute that the votes were counted incorrectly. And then we get to this, I'm sorry, the people who chose to use some other ink color. I mean, I know this gets outside, the statute, but these people were instructed by the head of the Republican Party, Kelly Ward, and by Mark Fincham to deliberately use blue colored ink and other things to mess up the ballots. I mean, that these people deliberately chose, for whatever reason, to disregard the election, the direction of elections officials and use some other color ink pen. That's on them. I mean, that certainly isn't misconduct by any elections official. So, Your Honor, I think we rest on what our papers are. We haven't heard, again, the first and last name of any breathing human walking this earth who was somehow denied the ability to vote in an Arizona election. And we're 5 weeks from election day. They can't name one such person. And the fact that they can't even name one at this point, standing alone, means that this case should be dismissed.
Thank you, Mr. Barr. Mr. Gayona, before you talk, I guess I have this question. I've been doing election cases now for 7 years, probably done a couple of dozen of them, and this one is so much different in than the ones that I get after the nomination ballots are put in. This is the first post-election, but it's got some of the same statutes address it. This is a contesting an election. If you could talk about the difference in what I'm supposed to be looking at in this type of a contested election as opposed to something that has a bigger time frame and nomination ballots that I have done in the past.
Your Honor, it is true that most of the cases that you've heard, in fact, I know I personally have had some cases before you that are challenging various types of petitions and also in the initiative context. And I'm not sure, specifically what differences the court is looking for, but obviously here we have a very limited universe of statutes that the Arizona Supreme Court has said control these proceedings. The court does not have jurisdiction to consider either grounds for a contest that fall outside of those statutes, nor does it have jurisdiction to grant relief that falls outside of that which is set forth specifically in the statute. So that is that is really the focus, Your Honor. It's on the statute. And so that's why, for example, the secretary's motion to dismiss and for that matter, the contestees as well, is focused on what does the statute say are the grounds? And does this complaint meet the bare minimum for pleading an election contest, not only looking, as I mentioned earlier, at the familiar concepts that we look to under Rule 12b-6 and Rule 8a for a sufficient complaint, but pairing that with the substantive law that undergirds an election contest. And so with that comes all of the presumptions that I mentioned earlier. And it also comes with the fact that you have to show that the result would have been different. Now, I know Mr. Lasota likes to look at that word uncertain in the abstract, but consider the scope of what he's asking here, Your Honor. What he's saying is that it is enough for a plaintiff to come in and say, my race was close. I think there were some problems. I can't identify anybody who actually had any of those problems. Ergo, the result is uncertain. Ergo, I get to inspect ballots across the state. And ergo, I get to go to trial on the merits. That's not a sustainable model for how election contests should work, Your Honor. It's not how the legislature intended that they should work. And it's not how this court should allow this election contest to proceed. And the different, I'm sorry, Your Honor, I interrupted you.
I interrupted you, and I apologize. When would it work? When should it work? I mean, if it doesn't work in an election where about 500 votes over this many, and the recount isn't even done yet, I understand that. But when would somebody, when we show some deliberate error or some sort of more than mere omissions, is that when it would work, an election contest, when there's evidence of that?
Certainly, Your Honor. I think there's the Picacho Peak case there, and there's a perfect example where the margin, and I'm going to get the numbers wrong here, but I believe the margin was something like 15 votes, and it was found that there were something like 42 votes that were procured illegally. There was proof of that, and there was proof that it would have made a difference. But what there is not anywhere in the case law, and plaintiff has not cited you any case, in which a court has said, well, the result is uncertain, therefore I'm going to throw out the results of the election. That's the standard that the plaintiff here is asking you to apply, and it's not the standard that exists under Arizona law. Mr. Barr talked a little bit about the fact that they can't identify a single voter who was affected by any of these things. And that is the fundamental problem with this case. Not only is the conduct about which they're alleging not misconduct under the statute, they do not allege a sufficient number of illegal votes or an erroneous count of votes that would flip the result of this election. Both of those are independently fatal to this claim. These claims, I should say.
All right, thank you. I guess, Ms. Kreger, did you have anything else?
I have nothing else. Thank you, Your Honor.
All right, well, I want to thank everybody for arguing this particular issues. I'm going to write an opinion. My goal is to have it done by 2 o'clock tomorrow afternoon, so I'll have an opinion on these issues, taking these motions to dismiss under advisement, and I'll have a ruling in writing by 2 p.m. on Tuesday, December 20th, 2022. We have the pending motion that Mr. Lasota filed for inspection of ballots under 16377 and the request for expedited discovery, and I'll let you argue those. I know that Ms. LaRue wanted to, and the county wanted to argue the opposite of those. So, Mr. Lasota, your motions.
Thank you, Your Honor. So I think Your Honor kind of identified the fundamental. I'll just start with the petition for inspection. The other discovery we're asking for is actually quite limited, and it should be expedited. But as I put in our pleadings, that look, there's another basis to require that, and it's under the Public Records Act. I know we've had a lot of those lawsuits this session. The county has generally worked very hard to accommodate requests on a short timetable, and I am thankful for that. But I think that it's just some of these things that the other discovery I think is fairly easy that ought to be able to be worked out in short order by the parties. But I know the the ballots are the big ones, and I think the court sort of identified the issue, and that's, well, why do you have the statute if you have to sort of allege something ahead of time that you can only show with the ballots? And I think that's fundamentally it. I mean, this notion that that we've offered no evidence is simply not true. And I think Mr. Barr kind of gave away the position of his client anyway, that, look, if you use a different color ink, it's your problem and your vote shouldn't be counted. That is not Arizona law. And the other thing I think he said is the reasons for people using a different color ink. I don't know. I mean, maybe there are people who just want to be difficult, but I think it's more there's perhaps misinformation out there about what color ink is actually most easily read by the machines. And for some reason, and I don't know why somebody would think something other than black would be the best color to pick, but I don't think it follows from that that we get to Mr. Barr's thing. Well, so what, right? Who cares? They used a different color ink, so their vote, and they followed sort of poor, misguided advice from someone, or whatever reason they did it. If you use a wrong color pen, you're just out of luck. That is simply not the law. And you're supposed to, when it comes down to ballots that need sort of a little extra something in them, you're supposed to look at the voter's intent. And that's why we have this whole duplication. We got adjudication. We've got this process where you can't quite tell, the machine can't quite tell. We go to that process. Now, the other thing I would mention is if the machine just says, hey, this is an undervote in this race, it doesn't really go anywhere. That's kind of the end of the line. And that's exactly why we need to inspect these ballots. And we're not talking about all the ballots. And even if we were, I mean, I think we've got this contest, and I think it needs to be seen through. And I think that's the bottom line on that. There's no particular, we want it to be done as expeditiously as possible. We don't want to interfere with any sort of other function of government, including succession. And yet I think we are on schedule to start this matter under the statutory time frame. So I think that is the statutory consideration. I know there are certainly other considerations. We are working very hard, and that's why, one of the reasons we agreed that, look, that they get to argue their motion to dismiss. We did not object to that. But I think the bottom line is this notion that if you were misinformed, just plain misguided, and you use the wrong color ink, the government told you to use this color ink and you use the wrong one, so you're out of luck. That's not the law. And I think that encapsulates as much as anything why we need to look at a limited number of ballots that we've asked for. So with that, I'd be happy to answer any questions.
All right, thank you. If I have any, you get to respond. So we'll go from there. I'll start with you, Ms. Krager.
Thank you, Your Honor. So I'm not entirely clear. I think, are we only discussing the request for ballots now? Is the other request for additional discovery continuing to be pursued?
Sounds like Mr. Lasota is optimistic you can work those things out based on your history. If there is some issue, he can address it in the response, and I'll let you address it if there is. But go ahead and just address the inspection of ballots issue. Okay.
Well, I would remind your court, Your Honor, that the rules of civil procedure don't apply in this. They're making a request for protection, essentially. Yes, there are public records requests. The county has responded to numerous requests. There's been other litigation related to that. But in this action, the only discovery that's available is a ballot request. And with respect to that issue, there's two things I would like to raise. The first is that their request to inspect the ballots personally is not allowed under the statute. 16677B provides only that a 3-person panel can conduct this inspection. But the other issue with respect to this, is this question on the 50,000 plus duplicated ballots. So in this theory, that is incorrect, that this number is created by people using the wrong color ink. So there's some facts I want to clarify. First off, the ballot instructions very clearly state that you need to complete your ballot with either blue or black ink. You can't use red ink, you can't use green ink, and you can't use a highlighter. These are the things that can't be read by the tabulation machine, and that information is provided to voters. The other issue that I would like to raise, Your Honor, is that the oval that people fill out in Maricopa County is set to, I believe, 8 to 12%. And because the oval is black, 4% of that is already completed. So a very, very minimal amount of ink needs to be placed in an oval in order for that to be triggered as either a stray mark or can go to adjudication if necessary, or to be considered a completed oval and a vote. So this idea that the machine is not sensitive enough to detect these things is simply not based in fact. The other problem, Your Honor, is, and as I said earlier in my statements, the theory that plaintiff has is that a person used the wrong color writing implement to complete their ballot, therefore the machine couldn't read it. If that's the case, unless a person is completing every race with a different color of pen or writing implement, then the entire ballot is not going to be read. And that is a very small universe of ballots versus the 50,000 that the plaintiffs are alleging here. And that 50,000 is not segregated by the county. So it is it is impossible for the county in this time frame to pull the 50,000 duplicated ballots, these 50,000 ballots that had undervotes related to the AG's race. So, for that reason, the county objects. And I also would like to point out that the county already is going to be in a hearing on Wednesday and Thursday of this week. It's currently scheduled in the Lake matter. And tomorrow there is some ballot inspection already happening related to the Lake case. So I just want to put these sort of logistical issues on the court's plate as well for consideration. Thank you, Your Honor.
There's a specific inspection of ballots going on in that case?
There is a 3-person panel looking at a small sampling of ballots in the Lake case.
All right, thank you.
Yes.
Mr. Barr, did you want anything to respond to this specific motion?
No, Your Honor, I would just join with Maricopa County and Secretary of State.
All right, Mr. Gaona?
Your Honor, I have nothing to add other than to reiterate the point made in the Secretary's response here, which is that we do not believe that any inspection should occur before the court has ruled on the motion to dismiss. Presumably, these would all be wrapped up into one, and that if there is to be a ballot inspection, it must proceed as prescribed by the statute, getting back to my point earlier.
Thank you. Mr. Lasota, you get the final word.
Thank you, Your Honor. So in terms of I think we have a misunderstanding here in terms of whether undervotes are duplicated and an undervote or adjudicated, and they're not. An undervote is just machine says, you know what, we don't have a vote in this race. That's essentially what an undervote is, and I don't think it goes to adjudication or duplication. And I think Ms. Krager admitted that at the end, but and that's generally speaking, but I think she mentioned that they had 36 adjudications and maybe about 4, but so I that was a mistake getting into that specific amount of numbers that she actually mentioned. But bottom line is, these don't go before a human eye typically, and that is why we think they need to. In terms of the other thing that was said is, well, if it didn't pick up any of these votes, it wouldn't, if it's not picking up the AG's race because blue ink isn't used, then it's not going to pick up any races, other races. And that's not true. What we're saying is the blue ink is less, or whatever color it is harder for the machine to read. So whereas, maybe the person fills out a portion of the oval on the AG's race, and it does not get picked up with blue ink, and it does not get picked up by the machine, but they're a little bit better on the next race, and they fill out more of the oval, and so that vote is picked up. So in terms of, we think that, that this notion that you're going to have 50,000 blank ballots is just not accurate. We're not saying the machine cannot read blue ink. We're saying it is less efficient, is less able to read blue ink, and in a race of this small of a margin, I mean that could make the difference. And so these voters, if they did fill out a portion of the oval, then that should be counted. I understand Ms. Krager's point. She says 8 to 12%. We say that the machines, I think we say they're set to 14%. We think the bottom line is they're not set at the proper setting to pick up these votes. And I don't know which it is. Is it 8 or 12%? That would seemingly be important, but our expert says they're set to 14%. So in terms of the, it's those are the only real points I wanted to make. Mr. Gaona, with the ruling on the motion to dismiss, again, we had no problem with the procedural posture of arguing that. I know some people in the past had made the argument that, well, let's just proceed with the merits and no motion to dismiss. But obviously we have no problem with the procedural posture. The one other thing I will mention is we did do a notice, just as the contestee, Ms. Mays, did. We did do a notice of supplemental authority on the Kerry Lake challenge, where she trails by over 17,000 votes, and the court did allow, and it is, in fairness, it's a limited access to the ballots, but the court did in fact rule in favor of Kerry Lake in terms of her right to inspect the ballot. So you should have that in the file somewhere, Your Honor. I know there have been a lot of filings, but I did file that this afternoon, maybe about noon. Excuse me, it was more like 10 a.m. So with that, I don't have anything else, Your Honor, unless you have questions.
I do have one question. It's from one of the people listening in, asking which counties you're asking to inspect ballots. I noticed in the petition to inspect ballots, there's a reference mostly to Maricopa County, but there was also a reference to Navajo County, who, if I recall correctly, on Wednesday, that attorney did not appear, is not here today, but that was Mr. Brown, I believe. But that was just a question. Where were you, if you are going to request to inspect ballots, where were you requesting? Was it all the counties or Maricopa County?
Your Honor, we would like to, the ballot inspection would be Maricopa and Pima County. That's what we would request.
All right. So I based on what you said during the middle of that argument is kind of what I was going to do anyway, as I think I need to rule on the motion to dismiss first, and I will address, if I don't grant the motion to dismiss, I'll address it either way by 2 o'clock tomorrow, whether I'm going to grant the petition to inspect. So it is already taking under advisement of all these motions that are pending. Is there anything else I need to take up today, Mr. Lasota?
Your Honor, I'm sorry. I should have said Navajo also on the inspection.
All right. You did mention them in your
in our complaint, yes.
In the petition specifically too.
Right. So.
All right.
Other than that, I don't think I have anything, Your Honor.
All right. Anything else, Mr. Gaona?
No, Your Honor.
Mr. Barr?
No, Your Honor.
Ms. Krager?
No, Your Honor. Thank
All right, thank you, everyone. I'll get something out by 2 o'clock tomorrow. We'll stand at recess.
Thank you, Your Honor.
Thank you, Your Honor.